Hey guys, Tammy here, and this week we are going to talk about child custody trials. Now, seems like I've had a lot of clients lately who are getting ready to face this, some with attorneys, some that don't have attorneys, and many clients don't understand the magnitude of what's really involved in a trial. So I'm going to try to shed a little light on this subject for you today. Before we dive in, let me just quickly remind you, if you're watching this on YouTube, don't forget to hit like and also subscribe to the channel so you get notified when new videos are released. So let's talk first about what is a trial. And this can go by many names, and I think people get really confused. Of course, in law, it seems like everything has many names, right? And so this can be called it's obviously it's called a trial, and it can also be called an evidentiary hearing. That means the same thing. And it can also be called a long cause. So a regular motion, which is, essentially usually about a 20 to 40 minute hearing, and that can vary in different states. But as a general guideline, that's about how long that the court allots for just a regular motion. Now, most of the time in family law, your testimony is taken in written form. Most courts do the vast majority of family law cases based on written declarations, or sometimes called affidavits. There's that two words for one thing again. Declarations or affidavits. Most courts will take people's testimony through that written form because it's a time saver. The court can read it ahead of time. The party has to sit down and write it out. It's more thoughtful. It's more specific. It gives the court kind of a brief on what's going on. And so for regular motions, again, those kind of like 20 to 40 minute issues, most of the stuff is taken through the written form. Not to say that the court can't take oral testimony at a trial, at a regular motion. It's just most of the time they don't, because again, we're thinking it's a short amount of time. It's a simpler issue to resolve, and we're going to do everything on the written declaration. When you get to trial, you're not testifying through the written form anymore. The court is going to take live testimony. So, again, the trial can be on more than one issue. If you're in a divorce case and you haven't settled, and you've been, in line for a while, you're coming up on a couple years or 3 years or something like that, you might be going to trial on your whole case, right? It might involve custody and support and all your assets and debts. It can be on every issue. Maybe you have an issue over what the date of separation is, all these different things that can be in disagreement in a divorce case. But judgment is what's entered once the entire case is completed. Well, it's not when the court is just doing these little one-offs on custody or support or the family home or these little issues. It's when you get down to the whole kit and caboodle being done, that's when you actually get a judgment of divorce. And most people think of a judgment as their decree, right? If you were married to the other parent. That kind of gives you a big picture of what a trial actually is. Now, let's talk about the procedures, because, if you're self-represented, this becomes a huge undertaking. A trial becomes a huge undertaking for a self-represented person. If you're going to trial, I prefer that you have an attorney with you. I'm not saying you can't do it if you have to. Some people have to. Some people simply don't have the funds and they have no choice and they have to do it themselves. But in the vast majority of cases, this is where you are really, this is what you're paying your attorney for. This is the knowledge, the experience, and, the thinking on your feet and all the different things that the attorney has learned throughout the years. This is where it really comes to bear in a situation like a trial. Thomas used to say that essentially he needed 1 hour of prep for every hour of trial that was set. So if he had a 2-hour trial, it was going to take him at least 2 hours just to sit and do his thinking and, his working up his examination and his cross exam and all that. I'm not even talking about the paperwork part of it, of like the trial brief and the exhibits and all those things. That's all totally separate. I'm talking about just him sitting down, thinking, strategizing, going through what's going to happen in the courtroom, what all of his questions are going to be, and all of that type of process. He said 1 hour for every hour of trial. And can you imagine? He practiced law for 30 years, and it took an hour to prepare for each hour of trial. So if you're going at this on your own and you have not been doing this for 30 years, it's probably going to take you far longer than that to prepare for each hour of trial. So you really do need to start in advance. And I will tell you that most people wait too long. They wait too long to consult with an attorney. They wait too long to start on the paperwork. It gives them fear. It gives them anxiety. They don't know where to start. So they procrastinate, right? We procrastinate on things that are difficult or that cause us anxiety or stress. So your tendency is going to be to procrastinate on this issue, but that is only going to make it harder on you. It's going to make your situation worse, and it's going to give you even more challenges than what you normally would have had if you had just confronted the fear and moved forward in your process. You also want to look up some guidelines for giving testimony. Almost every attorney I know has, some sort of cheat sheet or guideline or something that they give clients for when they're going to testify. And the problem with, testimony is that, it can really it can be used against you, right? Like anything that comes out of your mouth, can then be used by the other side. So you have to really put some thought into this and to be very thoughtful when you're on the stand about how you're going to testify. If I was going to give you any number one tip for your live testimony, it would be this: be honest. Be brutally honest. The last thing that you want to do is to get on that stand and give a less than honest answer that is then brought back by the other side, proved to be inaccurate, twisted or used against you, because what happens when that happens is all your credibility goes down the toilet. And then it becomes like everything that you've said up to this point is invalid almost. I've seen that happen to a lot of people in these situations. I've seen many times where clients will come out of a trial feeling like the attorney didn't do or say A, B, C, or D, or they're not happy with the outcome or whatever. And honestly, that's your job on the stand, is to know ahead of time what you need to say, what points you need to bring out, what points are persuasive for the court, what points aren't. If you do have an attorney, usually they'll meet with you to prep you before trial so that you can, kind of talk through all the different, evidence that they're trying to present to the court. But again, they can't tell you, say this. They're ethically not allowed to do that. So you've got to be able to come up with the goods, so to speak. I always say your attorney is only as good as the information that you give them. So if you're not giving them the right information, they're not going to be able to be as helpful to you. When the questions are finished, then the other side gets to cross-examine. And so if the other side puts your ex on the stand and the attorney gives a direct examination of your ex, then your next job is to cross-examine. And so you have to figure out what questions you want to ask. I think this is a little more challenging because you don't go in knowing exactly what their testimony is going to be. So you've got to kind of think on the fly. You might have some things written up for your cross-examination, but again, you got to think on your feet to be able to know, based on what they were asked in the first instance, what things that you need to cross-examine. The last thing on the testimony is objections. And again, honestly, I don't think I could do objections. I don't think I could even pretend to pull that off, even with having watched hours and hours of Thomas doing trial, even with all the paralegal work and all of those things. Objections are very, very difficult, and you have to know when they apply and how they apply, and you have to be able to give the reason. You can't just objections and say, objection, relevance, and then, you have to be able to give the justification for that, and it like, okay, not if you're the one objecting. Like if you say objection relevance, then if the other side is objecting to you and they're saying objection relevance, then you've got to be able to say, well, Your Honor, it's relevant because of this thing. And it can't just be this thing that you think is important, right? It's got to be a basis that comes under the law that says this is why this issue is relevant that I'm asking about, if that's the particular objection. There are many, many different objections. So objections would be one of the main things that I would research. Again, very, very complicated. This is where your attorney earns their money. I don't know any attorney that, well, I shouldn't say any. I know very, very, very few attorneys that actually enjoy going to trial. Most of them find it very stressful, don't like it and prefer to avoid it, where possible. And partly because it's so costly for the client, it's so emotionally difficult. And in family law cases, you have to co-parent with this person. And this does a lot of damage to that relationship. Again, you got to do your homework. You got to put in the time if you're going to self-represent. You got to get your butt to the law library. You got to do research. There are certain law libraries online, so research if there's any in your state. There's some procedures you can figure out that way. Research your local rules of court. Meet with an attorney, at least get a consultation, get some guidance for your local jurisdiction. Even if you can't afford a full-blown retainer, at least meet with someone and get some guidance. And if you can afford a retainer, my recommendation on a trial is retain an attorney. So I hope this has been helpful in giving you guys some overview. Like I said, I feel like a lot of people that I've talked to lately have this issue coming up and don't really understand what it looks like. And so I really wanted to kind of give you some reality checks on what to expect in this process. If you would like to learn more about my coaching services, please go to Divorce University Online /VIP-coaching. There is a link there where you can book a free strategy session with me. We can discuss your situation and see how I might be able to support you in this process. Thanks so much. I'll see you guys next time.
We'll grow in number, fueled by them to see the horizon, turn us to thousands.